Member of Parliament elect. He willfully disobeyed the orders of the court and went straight to Parliament and availed himself for him to be sworn in as Member of Parliament. And he has since then been calling himself out as the Member of Parliament. We are a country of rules. We decided then to petition the court as pursuant and consistent with the rules of court, which is under 50 of CI 47, that he had willfully disobeyed the orders of the court. Now the case was moved, the motion was moved, and it was slated for today for ruling. Today the court, you would notice, you were all in court.
This house, the information before this house is that the honorable member for Akwatia has been convicted. And he's become a fugitive of justice. He's a fugitive of justice. Mr. Speaker, for what follows conviction is sentencing. What he should be doing is to sending his lawyers to the court, to the High Court, to submitting a plea of allocutus, a plea mitigation, pending sentencing. So, Mr. Speaker, we will not, and with all due deference to my leader, he gave a direction. Yes, by all means, we'll take that. But we yield the floor. We will not disengage, we will not depart. We will not participate in any proceedings that will allow the honorable member to have locus to make submissions on the floor. It won't happen.
Well,
Mr. Speaker, so let me conclude by saying that the minority leader.
As for the NDC, if they think that today they are using Ernest Kumi to do politics, today is Friday, we are reminding them that next week Thursday, the president will be coming to the chamber. We are reminding them. They've forgotten that they are in government. We are reminding the NDC. So, if today they are the avant-garde of the rule of law, we've heard. Good. On Thursday, there are other matters of social justice in the country that perhaps they have overlooked. So if they are
Akwatia MP Ernest Kumi, to say I say court a convict a branty na eno na akopium ewo eye parliament na ne okopium a enyasem ketwa eye Afenyo e de asiani one MP baako kyese o so memu agem opete no asia no wa hwetenem si ano ayedin one eye asem wo parliament o ye be kwa akotie enzam ahodo e course wo parliament oba so like page na no first da betima like page no na eye pa na asi enu nti eye Akwatia MP ni case ya ba beto ho a ekofa asem e de abai yendo asem no mosuko ne hwe ade kropotin asi yenko court ne yenkohwe omu nkyire ye ede ne course wankasa akofa we nyina ba.
You would recall that sometime last week we moved an application to have Ernest Kumi convicted and sentenced to prison for his willful disobedience to the orders of a court of competent jurisdiction, that's the High Court of the Republic of Ghana. You would also recall that this case has been on since the 31st of December 2024. And the case essentially has been that Ernest Kumi, that's our case, that he was not validly elected. We followed up with a motion for interim injunction, which motion was granted for 10 days. Now, on the day that the Ernest Kumi was served with the said order, he filed an application to have it set aside. Now, the court heard the application and on the 6th of January 2025 dismissed it, and thereby insisting that he should not hold himself out as the Member of Parliament elect. He willfully disobeyed the orders of the court and went straight to Parliament and availed himself for him to be sworn in as Member of Parliament. And he has since then been calling himself out as the Member of Parliament. We are a country of rules. We decided then to petition the court as pursuant and consistent with the rules of court, which is under 50 of CI 47, that he had willfully disobeyed the orders of the court. Now the case was moved, the motion was moved, and it was slated for today for ruling. Today the court, you would notice, you were all in court, that before the court gave his ruling, lawyer Gary Nimakun was on his feet and wanted to be heard, that he had filed some processes and thereby sought to stay the hands of the court from delivering his ruling. The court said, I don't recognize you. And I must say this, it is a bit shocking. And we lawyers don't usually critique one another or each other. I mean, because we have been trained not to. But I'm a bit surprised that Mr. Gary Nimakun would rise in open court in a contempt case, which we all know, we've all been trained and are aware that contempt proceedings are different from, because the standard of proof is even different. It has a different case number. And so what an Ernest Kumi should have done was to either file an appearance or bring his lawyer to file an appearance. An appearance is done, it's a document that you need to file. Or because it's a quasi-criminal matter, like anybody who has gone to steal a sheep or a fowl, you have to be present in court to purge yourself of the contempt. You don't send a lawyer who has filed nothing. And you would recall that since the inception of this case, Mr. Gary Nimakun has always been coming to court, and he hasn't even filed an appearance consistent with Order 9 of CI 47. And this is serious, but we are waiting, and we will meet him at the Supreme Court. That's a different matter. But you see, today the court said that I don't recognize you because you are not the contempt, no, you are not Ernest Kumi, and you haven't filed anything in this case. So who are you in the matter? So the court said I won't even record you. And so that is why that arbitration happened, and then Gary had to be in his seat for the court to proceed. Now the ruling happened, and the court essentially is saying that indeed all the ingredients in all the authorities he listed proved that he willfully disobeyed the orders of the court, and that irrespective of your opinion about an order of a court, it doesn't give you the license to disobey it until it is set aside. No court, as we speak, has set aside or did set aside the interim injunction. And so he was completely out of order to disobey the orders of the court. And so the court said that when that happens, the law is clear. You need to be convicted and sentenced. And so the court today convicted him. That is, the procedure is that, you see, the court cannot give his sentence in a vacuum. So the court at this point has found him guilty. That's the meaning of the conviction. When the court says that you are convicted, it means that you are guilty of the offense. Now, because he was not in court, the court now says that he now issues a bench warrant like any other criminal. And the police, the national security, should go after him wherever he is and be arrested and brought to him in court for him to be sentenced appropriately. You would also recall that the comment about it. Initially, I wasn't served, neither my client, but the court sought to give the indication, and he said it in open court, the learned trial judge said that it was a letter emanating from the minority caucus of parliament. And you would see the distinction, it's not from the Parliament of the Republic. Because the parliament is being run by the clerk to parliament and the speaker. The letter didn't emanate from the clerk. It came from their own caucus and said that he could not come to parliament because he was undertaking some serious business. Now the court said he would not even entertain that letter, because if he did, it would amount to an inconsistency on his own part, because he has ruled that the gentleman cannot hold himself as a member of parliament. So if he is in parliament now and the letter emanates from the parliament and says that he is busy conducting parliamentary duty, the court will not even look at it, because the court doesn't even recognize that he is indeed an legitimate elected member of parliament. And so essentially that's what has happened. So as we speak, by close of today, the security forces are going to be alerted that they should arrest Ernest Kumi and bring him to the court, the High Court of the Republic of Ghana, for his sentence. It is then that the court would pronounce a sentence on him. But at the moment, he is a convict. The court has duly convicted him, and the conviction essentially means that he has been found guilty of contempt of the High Court of the Republic of Ghana. So that is what.
Emunchire mu na ya omode abre eye Ghana fu nyina hye ti na Akwatia MP ze ya ye kasa yi enya asem ketwa na omuwie ye no parliament hwa o se ebasa na omunyina MPs no omedidi hu nkomo afan obi abeche na adwene de afa ho de na adwene ye no de opeso wo kan ne ade obi abeche na adwene afan eno ene kopie mu parliament ena eye mpanyifo wo parliament nso bo eye esi eye platform time oma wie parliament adwuma no ene omo ne media edi nkomo efa ho.
That a contempt matter is a quasi-criminal matter, claiming that the lawyer should have filed an appearance. When somebody came to you earlier, you allowed the person to open the phone to give you details of a certain WhatsApp or a certain publication. But a lawyer comes to stand in for a client in a contempt matter. You are asking the lawyer to file an appearance in a quasi-criminal matter. Hey, Justice Senor Amedehe. At this stage, let me state further that legal steps have been taken. A notice of appeal has been filed against the ruling of the High Court at the Court of Appeal. An application for stay of execution pending appeal has also been filed at the High Court, number 3, Akufo-addo. Moreover, all the parties to the certiorari and prohibition application, including the judge, His Lordship Justice Emmanuel Senor Amedehe, who is the respondent to this application before the Supreme Court, have been duly served. Further legal steps would be taken, and the minority caucus in Parliament will address the Ghanaian public.
It's minority for and so eba bekasa. This MP for na kwa minority to only two. Enti Afenyo ebe so microphone mu and also so be che na adwene e wo case ho na ne na nya asem ketwa.
As for the NDC, if they think that today they are using Ernest Kumi to do politics, today is Friday, we are reminding them that next week Thursday, the president will be coming to the chamber. We are reminding them. They have forgotten that they are in government. We are reminding the NDC. So, if today they are the avant-garde of the rule of law, we've heard. Good. On Thursday, there are other matters of social justice in the country that perhaps they have overlooked. So if they are showing us the path of social justice and the rule of law, we have heard them. From Tuesday, we, the minority, God willing, will also begin the process of bringing to the fore all the issues that the government must undertake to bring social justice in our country. And we will not limit it to Tuesday. We'll go on Wednesday, go on Thursday, Friday, and we'll continue until all the issues of social justice are addressed. So we thank them for forcing an adjournment today. We thank the NDC majority caucus. We thank them. These are useful lessons.
Young proceedings na nkasa wo parliament. Edi na course time one no more discuss efa eye owura Kumi case ya beto hoyi a omo kire se court say o mache no eye contempt bi ni ade a omo ka ho asem no Kumi ekopie mu anase na asem no kopie mu parliament no yenhwe how a minority ene eye majority discuss ye na hit we dey utimi say Afenyo Markins ko ye meeting meter ba
on the proper law. Let me now respond to him on the proper law. But as smart as he is, and as I know him to be, when he was landing, he argued some law to create a ventilation for his own argument. And that is that ventilation that I will use to arrest his argument. What was the ventilation? He said, unless the member has filed an appeal and is staying the execution of the order. So, Mr. Speaker, as smart as he is, he created that ventilation. I am able, as a leader of my side, to provide him with that information. That, Mr. Speaker, if his concerns is about the rule of law, this side would always respect the rule of law. The honorable member has indeed filed an appeal, filed a stay of execution, and for your information,
there was a stay of proceedings. There was a stay of proceedings application pending before the very judge. A stay of, yes, and you are a practitioner. A stay of proceedings application pending before the very judge. Mr. Speaker, there was also an application invoking the supervisory jurisdiction of the court, of the Supreme Court, under Article 132 of the Constitution. Mr. Speaker, the court below, the High Court in Akwatia, had been served, and the registrar of the court indeed had brought that process to the attention and notice of the judge. Mr. Speaker, our side, even where we disagree, will not go insulting judges. The fact that we have been quiet does not mean that we think the judge has been fair to us. And you will not see us calling the judge names. We are not like some people. We are not like some people. When we disagree with a judge, we will use lawful process and lawful means to challenge the orders of the court. Mr. Speaker, we are saying that there is a process pending before the courts. There is no finality in the matter in issue. The honorable majority leader who raised the matter knows very well that a conviction, even if the member has been served, the judge himself said he was going to have time.
Honorable members, honorable members, honorable, hold on. Yes, honorable Afenyo. Mr. Speaker, I thank you for the opportunity to intervene in pursuance of Order 1221A. First of all, it is most inaccurate for the minority leader to submit on this floor that the majority at the time, before the general elections of 7th December, we forcefully refused to respect the court order. It cannot be accurate. The terms of the court order were specific. The court orders were directed at the speaker to perform a certain function. And being the occupier of that seat, we submitted that until that decision was taken by the House. The status quo ante will remain. What was the status quo ante? Our position by occupying the majority side before the court decision. That cannot be erroneous in law. The court itself ordered that the House must take that decision. So for him to submit that we unlawfully, forcefully, and refuse to obey the court order, that cannot be allowed to form part of the records of this House. tomorrow it can be invoked against us. That's one. Two, Speaker, when you are convicted by a court of competent jurisdiction, you don't file stay of proceedings. They have been convicted. Waters have passed under the bridge. You are convicted. Please, I'm not misquoting you. I heard you clearly.
I was waiting to tell you. I was waiting to respond.
Speaker, I have not yielded the floor to the honorable minority leader. I have not. So you should listen to me in much pain and in silence. I know he'll come back. If you are convicted by a competent court of jurisdiction, conviction, what follows is sentencing. And that is what is pending in this matter. You don't file a stay of proceedings, with all due respect. Now, third, Mr. Speaker, I rose, Mr. Speaker,
Honorable Dafiama,
Mr. Speaker.
Listen. You see, he was speaking. I would have given you opportunity to also speak if you had allowed him to finish. I thought you were coming to a point. Coming on point of order, but
Mr.
please,
Speaker,
you've raised the issue. Let him finish.
Mr. Speaker, I am not. Mr. Speaker, I'm not done. I anchored my submission pursuant of Order 12218. I am not done. Mr. Speaker, you give the minority leader sometimes 1 hour to make submissions. I have not even done 5 minutes. So permit me. This house is a house of politics. What is doing is politics. It is not religion. It is not faith. It is not economics. It is politics. What they seek to do is politics. And we cannot allow politics to impugn the integrity of the courts. We cannot. Mr. Speaker, this house is mandated in law not to engage in an irregularity, in any unlawful conduct. We cannot participate in it. And we cannot allow the house, properly constituted, to engage in it. It cannot. So Mr. Speaker, this house, the information before this house is that the honorable member for Akwatia has been convicted. And he's become a fugitive of justice. He's a fugitive of justice. Mr. Speaker, for what follows conviction is sentencing. What he should be doing is to sending his lawyers to the court, to the High Court, to submitting a plea of allocutus, a plea mitigation, pending sentencing. So, Mr. Speaker, we will not, and with all due deference to my leader, he gave a direction. Yes, by all means, we'll take that, but we will yield the floor. We will not disengage, we will not depart, we will not participate in any proceedings that will allow the honorable member to have locus to make submissions on the floor. It won't happen.
Very well.
Mr. Speaker,
Very well.
so let me conclude by saying that the minority leader, an able lawyer that he is, eloquent that he is, should be advising his colleague to go and respect the court and submit to the powers of, even if you are proceeding to the Supreme Court or whichever court, you need to submit to the jurisdiction of the court first of all. You cannot be doing so as a fugitive of justice. An arrest warrant has been issued, properly issued, for his arrest. That this house cannot gloss over the issuance of an arrest warrant for him and I still permit him to have locus. Mr. Speaker, on this note, we want to urge you that, leader, if I have your permission, Let me move that the House be adjourned. The House be adjourned. Let me move that the House be adjourned.
Yes, leader, let me hear you.
Mr. Speaker, let me refer my colleagues to the decision of the Supreme Court on the 18th of October 2024. Mr. Speaker, this is what the Supreme Court said. The Parliament of Ghana is hereby directed to recognize and allow the 4 members of Parliament herein named to duly represent their constituents and conduct full scope of duties of their offices as members of Parliament pending the determination of this suit. Mr. Speaker, in his submission, the Majority Chief Whip said that the court decided that this House should take a decision. The court directed, if people are diluting their law with politics, they should dilute it properly, because these are reputational issues. These are reputational issues. The Supreme Court did not urge upon us to take a decision. It directed. And I submit that they refused to respect the decision of the Supreme Court. That is what they did. And today, I am directly confronting you with that decision you took in October. Mr. Speaker, that aside, in my earlier submissions, my argument was to the effect that prior to the conviction, the court was seized with an application to stay proceedings. I didn't say that the man filed a stay of proceedings. I didn't say the man filed a stay of proceedings pending appeal. I didn't say that. He had a stay. Mr. Speaker, I know some people are at the back there. I am aware they have finished the LLB, and I know they are still attempting to get to the law school. I am a practitioner. Mr. Speaker, I am a courtroom practitioner. I know courtroom practice and courtroom rules. So I'm talking law. And I want my colleagues to listen. I'm saying that Honorable Kumi had filed a stay of proceedings application, which application was pending before the court. At the time that the same court was seized with the application committing him for contempt, I was aware. And I am saying that the court, after its decision, there is a stay of execution and an appeal, notice of appeal. These two processes have been found. If they don't know, I'm letting them know now. It is most unfair for Mr. Afenyo to describe a respected colleague as a fugitive. Never again should such a statement come out of the mouth of a colleague? Maybe today you find it convenient, but trust me, come on, await each one of us. You cannot describe your colleague as a fugitive. The man has submitted to the authority of the court. Is the reason why he has filed a notice of appeal and has supported that notice with a stay of execution. There is a stay of execution application, a stay of execution. Meanwhile, Mr. Speaker, let me also inform this House that prior to the High Court coming up with that decision, the High Court was again seized with the application invoking the supervisory jurisdiction of the Supreme Court on its conduct, because the registrar of the court had been served and the court indeed was on notice, but the court decided to proceed. We don't mind, because we believe that we can still rely on judicial processes. And I did say that our side does not take to the insults. We won't go on the radio to insulting judges when we disagree with them. It's the reason why we have been most decent. We will not go attacking a judge on social media and be using unprintable words on judges just because we disagree with them. No. Mr. Speaker, the invitation to you to restrict is most unfair. That invitation sits on stilts. That invitation is not based on any solid foundation in law. And Mr. Speaker, an attempt to be hoodwinked into any valley of confusion would amount to a general confusion in this House, because the majority leader knows that he was only doing politics and not doing law. He knows that what he did was politics and not law. Mr. Speaker, in this House, how can a member of parliament who in the performance of his parliamentary duties has not been served with the court process? Mr. Speaker, let them sit quietly and listen. Let me finish my submission. Mr. Speaker, if they want, then we should. What? Yes. Well, that's all right. Why? We cannot respond to you.
Oh no, but no, you let me listen to you. I'll come
Mr. Speaker, he has to finish. He has to listen to me.
I'll come back to you.
He has the point of reply. He must. When Afenyo Markins speaks, many of you will get
Honorable members.
When Afenyo Markins, many points of order.
Honorable members.
When? Many points of order.
Honorable members.
You cannot
if
tolerate.
You wouldn't allow me, I will go ahead, suspend the House, and
you will not adjourn the House. Mr. Speaker, they want an adjournment. We would argue the case today. We will argue no adjournment. Mr. Speaker, we will argue. Let us argue the issues with the adjournment. You want an adjournment. You are running away. You brought your application, you are running away.
Honorable members,
brought your application, you are running away.
The time is 5 to 4 o'clock. You are in my hands. The House is accordingly adjourned.